Hello friends, in the series on the income tax cases, today we will discuss the case of RAJESH KATYAL versus Income Tax Department. This case has been reported in 451 ITR at page number 455. The matter has been decided by Delhi High Court and the date of the judgment is 3rd November 2022. This case is regarding the writ petition filed by the Assessee in respect of show cause notice sent by the department under section 53 for the alleged transactions which were entered into by the Assessee before 1st November 2016. 1st November 2016 was the date on which the Benami Act 1988 came into force. As all we know that the provisions of Benami Act are criminal in nature. When this act came into existence, there was a lot of apprehension among the assessees and among the professionals whether this act will be applicable for the transactions which have been entered prior to the enactment of this act. Because the law is very clear as far as the criminal proceedings are concerned, if any law is enacted, that cannot be made applicable from the retrospective effect. Already on this matter, the Supreme Court has given the decision in the very famous case of Union of India versus Ganpati Deal Pvt Ltd 2022, and this case has been reported in 447 ITR at page number 108. In which the Supreme Court has recorded the concession made by the Union of India that the offence under section 53 of the Benami Act is prospective and would apply only to transactions which were entered into after amendment came into force, that is 1st November 2016. In this case, the Supreme Court held that the Act of 2016, which contains the criminal provisions, is applicable only prospectively and quashed the proceedings initiated. So in this case, the assessee was strongly relying on the judgment of the Supreme Court because the show cause notice which was sent to the assessee was related to the transactions in between 2013-14 in which the assessee has some purchase shares of a private limited company in which the shares were issued at a premium. So the typical character of the transaction was near about Benami transactions. But because the transactions were not covered by the Benami Act, because the Benami Act came into existence on 1st November 2016 and the transactions were before that. So because the law is very clear on this point, that the criminal proceedings under the Benami Act cannot cover the transactions before the enactment of that act. So the assessee filed the writ petition in the Honorable Delhi High Court against the notice under section 53 which has been sent to him, that why your transaction should not be treated as Benami, why your property should not be treated as Benami. So the Honorable Delhi High Court, relying upon the judgment of the Supreme Court in the case of Union of India versus Ganpati Deal Pvt Ltd 2022, the Delhi High Court said that the notice under section 53 of the Benami Act which has been issued to the assessee should be quashed because it relates to the transactions which are prior to 1st November 2016. Friends, the law is very clear. There might be a number of the notices which are there for which the assessee is in appeal, or you can say that the proceedings are going on. So this judgment is very important as far as the Benami Act is concerned, because this act plainly does not allow the department to initiate the proceedings or to carry on the proceedings under the Benami Act for the transactions which are prior to 1st November 2016. This is a very welcome judgment, although it is a repetition of the Supreme Court judgment. But I think that this judgment is very important as far as the Benami transactions are concerned. At the end of this deliberation, once again I am repeating the name of the case. The name of the case is RAJESH KATYAL versus Income Tax Department, and this case has been reported in 451 ITR at page number 455. The matter has been decided by Delhi High Court and the date of the judgment is 3rd November 2022. Thank you, friends.